Law Center's Communications Associate. Thank you for joining today's webinar entitled Understanding FERPA, Sharing Education Records to Improve Outcomes for Children in the Juvenile Justice System. Before I go any further, I just want to do a quick sound check. If everybody could type me a little message in the chat box, let me know if you're having any audio issues. Great, thank you guys. It looks like the audio is coming through clearly for most of you, so I'll go ahead and move on. Today's webinar is hosted by Catherine Feely of Juvenile Law Center, and before we get started, I just want to run through some technical issues. If you're participating by phone today, your line will be muted during the entire webinar. If you have any questions during the webinar, you can type those into the chat box that appears in your GoToWebinar control panel, and that's that long rectangle to the side of your screen. If you need to collapse that control panel, there's a little orange arrow at the top of the rectangle that will collapse it in or pull it back out if you need to see the chat box again. This webinar will be recorded, and we will send everyone a link to the video and to any supporting documents mentioned during the presentation. We'll try to save some time today at the end of the webinar to answer your questions. And then please note that all materials, including the PowerPoint and publications, we'll be referencing, like I said, will be sent to you in the follow-up email. And we'll have these materials available on our website, www.jlc.org. So now I'm going to turn it over to our presenter today, Katie Feely.
Hi, everyone. Thank you so much for joining us. Again, I'm Katie Feely. I work at Juvenile Law Center, and this presentation was made possible in part by funding from the Open Society Foundations. And you will receive, in addition to this presentation, you'll receive our publication with the same title, Understanding FERPA, Sharing Education Records to Improve Outcomes for Children in the Juvenile Justice Systems. We'll be emailing it to everyone after this after the webinar is over, and it will also be available on Juvenile Law Center's website and on a variety of different listservs. I'd like to just do a quick poll before we start and find out who you are and what your interest might be in this particular area. So if Chelsea could put up that poll, that would be great. Thanks. So this poll asks what your role is in this particular topical area. If you're an advocate, if you're an educator, an administrator, if you work in probation, if you're a researcher, if you're otherwise employed. And this will help me gear my presentation a little bit. And I'll just give a little bit more time for you to fill this out. Okay, so it looks like we have most people are otherwise employed by state, local, and federal government. 9% work for probation, 13% are administrators or educators, 38% are advocates for children's educational rights. So we'll be hopefully addressing topics that will interest each of these professions. In the employed by local, state, and federal government, I didn't ask for specifications of who you all are, but please, if I'm not answering your questions, type them in and we'll try to get them at the end of the presentation. Now I'd like to give a little bit of a national context for why this presentation is important. Basically, you know, as many of us know, children in the juvenile justice system have a high risk of falling behind educationally and dropping out of school. And we know that sharing education records in a responsible way with juvenile justice stakeholders can help stop these negative outcomes. Recent guidance from the Department of Justice and Department of Education highlights this topic among others. It talks specifically about the importance of timely transfers of education records from homeschools to secure care facilities. The guidance doesn't specifically talk about detention facilities, but does mention that detention facilities should abide by these same principles whenever possible. And specifically, the guidance states that it's crucial for teachers and administrators to get this information because they need time to review it and analyze it so that school personnel can develop education plans for students, identify important supports and services for students, and also so they can assign students so they can continue accruing education credits that will serve them when they are hopefully sent back to their schools. Excuse me, everyone. So to that end, we're going to talk a little bit about FERPA, which is one law that impacts education record sharing. And specifically, we're going to talk about FERPA's default protections, some of its exceptions, and its application to the juvenile justice system. Then, in that conversation, we're going to specifically discuss the Uninterrupted Scholars Act and how it may affect certain children in the juvenile justice context. And I'll also hopefully give you some resources that might be helpful in further investigation of information sharing laws. At this time, before I go into a review of FERPA, I'd like to know your level of familiarity with it. So Chelsea, if you could just put up a poll so that I can get a better understanding of the attendees' level of knowledge about FERPA, that would be really helpful. Oops, excuse me. Sorry for the delay. I hope that poll is going up. And if it's not, I can just continue because I'm not seeing it on my screen. Let's see. Unfortunately, I'm not seeing the answers to your poll on my screen. This is probably just a little technical glitch on my part. So I'm going to continue.
Okay. I'll just go ahead and read the percentages for you.
Great, thanks.
So like 12% were very familiar, 23% were familiar, 35% a little familiar, and 30% unfamiliar.
Okay. So we have a range, and at the risk of boring the 12 and 23% of you who are very familiar or somewhat familiar, I might take a little bit more time going over FERPA. Feel free to tune out if you think these are things that are too much of a review for you. One quick note before we start on the FERPA review is what we're not going to cover today. And there are a lot of other important laws that may affect children involved in the juvenile justice system. They're listed on your screen. We're not going to talk about them, but there are a lot of other resources that I'll connect you to at the end of the presentation that do talk about some of these other important laws. And the publication that I mentioned from the Department of Justice and Department of Education, the link that you would have seen on the screen, that also discusses, for example, the IDEA and some other information sharing laws that are important. We're also not going to delve into the collateral consequences of sharing information between juvenile justice and some community schools. And this direction of sharing often triggers some additional concerns related to youth confidentiality. One thing I would just remind our advocates and our juvenile justice folks is that FERPA contains a provision for the amendment of a child's education records if the education records relating to that student contain information that is inaccurate, misleading, or otherwise in violation of the student's privacy rights. Excuse me. This process is detailed in 34 CFR section 99.20. All right, so here for our review. FERPA stands for the Family Educational Rights and Privacy Act, and it can be found in 20 U.S.C. 1233G, and regulations are at 34 CFR Part 99. The purpose of FERPA is to protect the privacy interests of students' education rights, and it does that by laying a default rule that prohibits schools from disclosing personally identifiable information from students' education records without the written consent of a parent or eligible student, unless an exception to the general consent rule applies. And who does this apply to? Well, it applies to private and public schools that receive federal funding. All right, now who are these schools that receive federal funding? These include any educational agency and institution that receives funds from any program administered by the Secretary of Education, and this includes local education agencies that administer education programs in juvenile justice facilities. Just wanted to make that clear. And it includes any facilities that receive department funding to operate on-site schools. In this webinar, we're just going to use the term schools to refer to any of these educational institutions that must abide by FERPA. And then unpacking this definition of who FERPA applies to and its purpose a little bit more, we'll ask, what are education records and what is personally identifiable information? So FERPA only speaks in generalities when defining education records. It states that they must be directly related to a student and maintained by a school or a party acting for the agency or institution. FERPA doesn't define what directly related to the student means, but many experts have suggested that this term should be synonymous with personally identifiable information, which is defined in 34 CFR 99.3. And it includes information like a student's name, the name of a student's parents or other family members, the student's address, or any other direct or indirect identifiers of the child. Another important note here is that the designation of a document as an education record really depends on who maintains the record, not who originates it. So a document that is directly related to a student and maintained by a district employee or any agent of that district could qualify as an education record, even if they are not the organization or entity that created the record initially. So let's talk about, for example, if you have a health-related record in a school that is located in a secure care facility, and that secure care facility has a nurse, and that nurse is employed by the school, and she maintains information directly related to a student's medical needs at school. That record would fit the definition above. And it's really important to know whether that definition fits whether the record fits the definition, because if the information is part of the education record, it's covered under FERPA. If it's not part of the education record, it's likely covered by some other information sharing law that we're not going to go over today, like HIPAA or like the federal drug and alcohol laws. And it's really important to know which law covers which information, because some laws have stricter protections on redisclosure and on disclosure. FERPA has some of the most strict protections on disclosure. So what's not an education record? So in addition to not meeting the explicit parts of the definition that I mentioned before, other parts of the record that are specifically excluded from being education records are records kept by the maker as notes. So this would be like a school psychologist who keeps professional notes on a child's demeanor and uses those for that person's memory as opposed to including them in any official record. Another thing that is outside of an education record are records of the school's law enforcement unit. And this is especially important in schools and in the juvenile justice settings because we wouldn't want a child's behavior to result in further involvement with the juvenile justice system when you have a non-educator or administrator who's basically taking care of a behavior issue outside of school. Those records need to be kept separate from education records. And I'll go, you can go over the definition of a law enforcement unit record. In the statute itself, it'll explain what those records are and how they should be kept separately. Another record that is outside of the education record are records relating to an individual's employment with the school. So a teacher, an administrator, those records would not be part of the education records. And finally, education records don't include any treatment records from outside providers when the subject of the disclosure is a student who is 18 years or older. All right, moving on to access and control. So who has access to and controls the release of these records? Generally, when a student is 18, the student's parents have a right to review the student's education records and to disclose those education records. And parents, but parents lose that control when a student turns 18 or attends post-secondary institutions. Then the student becomes what's called an eligible student, and they have the rights that the parent had. Note, though, that there is an exception to this rule for eligible students when the Uninterrupted Scholars Act applies, and we'll talk a little bit more about this later. One other question that might come up in the juvenile justice context, because it comes up in the child welfare context, and we know that oftentimes there's crossover between the populations involved in these two systems, is the question of who is a parent under FERPA. And FERPA defines a parent as a natural parent, a guardian, or a person acting as a parent in the absence of a natural parent. Just note that some jurisdictions consider a foster parent or other caretaker as the parent, and this is supported by the Department of Education's comments to FERPA in 61 Federal Regulations 59-291. And these are some comments that were put forth in 1996, and you can review these comments and your state's codification of FERPA for more guidance on who's considered a parent. Also note that the publication that will accompany this particular webinar has an appendix that includes some states' codifications of FERPA and specifically how they relate to the juvenile justice system, so that might be a place to start with your research. Another note would be that when a parent or eligible student wishes to release information that's in the education record, they must complete a written authorization which consents to that release of the information, and the consent to release has to have the elements that are specified on this slide. I'll let you read them yourself so that we don't bore the people who've done this before. This is the default rule now on redisclosure. Basically, if a parent or eligible student discloses information in the education record, this rule limits what the parties who receive the disclosure can do with that information. And the default rule is that the party to whom the information is disclosed cannot redisclose without prior consent. If the third party improperly discloses the information, there are penalties. The educational agency or institution may ban that party's access to personally identifiable information. I don't know of times when that has actually happened, but more often another repercussion is that the Family Privacy Compliance Office may release a letter that castigates the particular organization for improper sharing. And parents and others, in order to get such a letter written, would write a complaint to the Family Privacy Compliance Office. We're going to go over some exceptions to the parental non-disclosure rule. And one particular exception has its own redisclosure requirement, so we'll talk about that in the next few slides. All right. So in this table, you are going to see that the eligible student or parent non-disclosure requirement under FERPA is subject to a number of exceptions. And the first special disclosure circumstance we're going to discuss is the Uninterrupted Scholars Act, and then we're going to talk a little bit about how it may apply to some children in the juvenile justice system. In January 2013, the Uninterrupted Scholars Act amended FERPA basically to make it easier for caseworkers to obtain education records for children in foster care. The Uninterrupted Scholars Act, which I'm going to refer to sometimes as the USA, added an exception specifically for children in out-of-home child welfare placements, and these would include children in out-of-home kinship care, other forms of congregate care, and as we'll discuss on the next slide, or in about 2 slides, some children who are in Title IV-E placements. Here is the statute itself. I bolded the first part of the USA amendment. In short, it permits education agencies to disclose personally identifiable information from a student's education record without parental consent to an agency, caseworker, or other representative of a state or local child welfare agency or tribal organization if that entity has the right to access the student's case plan, and when that agency is legally responsible for the care and protection of the student. And that is provided that redisclosure protections are kept, and I'll talk about those in a later slide. Why was this amendment to make it easier for caseworkers to access the education record needed? And how does it affect students involved in the juvenile justice system who we're here to talk about today? The exception was needed because professionals who work in the child welfare system obviously need accurate information about their clients' education needs to support learning and make informed placement recommendations to the court. These, having education records in the courts helps assure that a child's living placements are close to schools and that those schools can provide necessary educational supports. And we know that prior to the USA, court orders were the only way for child welfare caseworkers to access education records without parental consent, and that this delayed receipt of records and inhibited the advocacy about living placements and educational supports. The Uninterrupted Scholars Act is important to certain young people in the juvenile justice system because it may allow any caseworkers involved with them to access their education records and provide this educational advocacy when, under state law, those students are considered to be, and this is the important phrase, the legal responsibility of a child welfare agency. So when might the child welfare system be legally responsible for a student if that student has no open child welfare case? Basically, the legal responsibility might occur if a child has been placed in foster care through the delinquency system. And this happens when a child is in a Title IV-E eligible foster care placement and meets other Title IV-E requirements for foster care maintenance payments. If you need a refresher on Title IV-E, let Chelsea know with a question, but otherwise I'm going to continue on and explain that in these situations the USA applies because the child welfare agency would be considered legally responsible for the care and protection of the student. Just note that other youth placed in foster care as a result of delinquency may also be considered the legal responsibility of the child welfare system, but you'll need to check your state's laws and regulations on Title IV-E funding and case responsibility structures to see which other youth could fit in your state's definition of being in the care and protection of a child welfare agency. Okay, now in this slide I've highlighted the second part of the Uninterrupted Scholars Act statute, which deals with the caseworker's redisclosure of information. Specifically, caseworkers receiving education records through the Uninterrupted Scholars Act may only share the records with others who are engaged in addressing the student's educational needs and are authorized by the agency to receive such disclosure. And the disclosure is consistent with state or tribal laws. So one question you might have is whether caseworkers may disclose to juvenile justice personnel, such as probation officers or a child's counselor in secure care. And to date, no federal guidance specifically addresses the release of information to these parties. But in analyzing a somewhat analogous scenario, federal guidance by the Family Privacy Compliance Office has explicitly recognized that independent contractors of child welfare agencies who are engaged in addressing the student's educational needs may receive personally identifiable information from a child welfare agency. Given such possibility, states might want to explicitly, in guidance, consider the risks and benefits of redisclosing a child's education information to juvenile justice personnel. The reason I say that states should explicitly consider risks and benefits is because we know that certain personnel, such as juvenile probation officers, have obligations not only to ensure a child's educational success, but also to report behavior to the courts. So because of that dual responsibility, your state may want to develop policies and protocols to ensure that education records that are redisclosed to parties can only be used for addressing a student's educational needs and not something like addressing behavior issues. Register. And I can address both of those questions. I can address the site for federal guidance shortly, and I'll just quick read over a Title IV eligible placement. So there are three main requirements for Title IV eligibility. One, children have to have been removed from relatives who meet Title IV financial eligibility requirements. Two, they have to satisfy, courts have to satisfy substantive findings that removing the child from home was in the child's best interests. And three, the students have to be placed in, or the child has to be placed in foster care, which is defined as a private child care institution or public child care institution, which accommodates no more than 25 children, and then there's a number of other qualifiers. But what's important is the term can't include detention facilities, forestry camps, training schools, or any other facility operated primarily for the detention of children who are determined to be delinquent. That comes from 42 U.S.C. 672 and 42 U.S.C. Part 3, Section C2. And a quick note on older foster youth, moving on, is that under the Uninterrupted Scholars Act, the students who are the responsibility of the child welfare system and are over the age of 18 are treated in the same fashion as they would be for students who are under 18. This comes into play if your state has extended jurisdiction of foster care for individuals who are over 18. And I was just told that the mic is going in and out. So thanks for the feedback. And I just moved the mic closer to myself. I will try to speak more loudly and more slowly. All right, this is the part of the presentation where we're going to talk about some other exceptions besides the Uninterrupted Scholars Act that may apply to students in the juvenile justice system. These exceptions include disclosure for enrollment in schools, a disclosure of directory information, and to the juvenile justice system prior to a child's adjudication. Also, schools may release a student's education record to certain officials without prior parental consent when the information is needed to either protect health or safety, or if the school is served with a court order or subpoena. So let's talk about the first of those exceptions now and how it might apply to the juvenile justice system. So this disclosure of to officials of another school in which a student seeks or intends to enroll is an important one. You may also want to look into your state and local laws, which may require that such disclosures be made, and it's not just permissible. If a school wants to take advantage of this exception, one important note is that the student's parents must be notified of the school's record transfer policy, and they must receive a copy of the record if desired and have an opportunity for a hearing to challenge the content of the record. So for example, when a student enrolls in school at a juvenile justice facility, the student's home school may transfer records to the facility school without first obtaining a parental consent, as long as the parents are provided with the opportunities described above. Similarly, when the student is later discharged from the secure care facility and returns home, the school at the secure care facility may transfer the student's education record to the student's home school if they allow for those previously mentioned notice and hearing opportunities. So I got a question about, can caseworkers disclose record to court-appointed special advocates who have a court order? And the answer is yes. That was part of this, the previous slide where I went over other exceptions to FERPA, and the last one says court order. So I'll go over a little bit more about court orders later, but the answer to that question is yes. And the next one is a little bit more specific, so I will wait till the end of the presentation to talk about that. Another exception that's important to discuss is the directory information exception, and that's important because it allows for particular information to be shared without a parent's consent. You can see those particular types of information on the screen. They include a student's name, address, let's say email, photo, date of birth, and dates of attendance. Note that the dates of attendance are not the same as a child's attendance record. Dates of attendance is a date range. Attendance records are actually part of a child's education record, and they refer to specific days a child missed school. Those are sometimes referred to as, for example, truancy records. So it's important to make that distinction that the attendance records are not directory information, but other records are. And again, parents must be informed about what is included in directory information and have the opportunity to opt out. So this would be true in a school in a secure care facility as well as a regular community school. Another exception that may apply to youth who are in secure care facilities is the juvenile justice exception. It's also sometimes called the state law juvenile justice exception, and there are very narrow circumstances when it applies. Specifically, educators may share information with appropriate juvenile justice system officials when youth are either at risk of involvement in the juvenile justice facility system or have been involved. If these conditions that are on your screen are satisfied, the child has to have not yet been adjudicated delinquent. State law has to authorize the disclosure. The disclosure has to be to a state or local juvenile justice agency. Disclosure has to relate, this is the important one, relate to the system's ability to provide pre-adjudication services to a child. And the state or local officials who are going to be receiving this information has to verify in writing that they're not going to disclose this information to third parties outside of the agency. At least 19 state statutes authorize this type of disclosure, and in our publication there will be an appendix that details shows you what some state statutes authorizing this disclosure look like. All right, so moving on, we're at the last two exceptions to FERPA. One is appropriate officials to protect health and safety. So this is an exception where the situation must constitute an articulable and significant threat to a student or other individual, and information must be needed to protect that individual's health or safety. And when this applies, the school may disclose information to only appropriate parties, typically law enforcement officials, public health officials, trained medical personnel, and parents are the types of appropriate parties to whom information may be disclosed. Again, for this exception and for all other exceptions, I would recommend looking at the Family Privacy Compliance Office's website. They have a number of frequently asked questions documents that discuss these particular exceptions. One other exception I'd like to talk about that addresses one of our attendees' questions is about subpoenas and court orders. Schools may release information in the education record without written consent to comply with an order or a subpoena, but the school must make a reasonable effort to notify the parent before releasing the information in the record. Prior notice, however, is not necessary in any of these situations. So number one, it's not necessary if a subpoena is from a federal grand jury and the subpoena is issued for a law enforcement purpose. And it's not necessary if the judicial order was issued in a court proceeding involving child abuse and neglect and the parent is a party. So that second exception to when reasonable efforts to notify parents are not necessary is referring to the Uninterrupted Scholars Act. And if you have a child whose records are being shared and that child is in the legal, it's the alternate to the Uninterrupted Scholars Act. If you have a kid who's the legal responsibility of the child welfare agency, you don't need to notify a parent if that parent is a party to a court proceeding in which child abuse or neglect is the issue. Okie doke. Now we're on to our final slides, and we should have plenty of time to go over questions at the end. And so one question I got, which I think is actually a good one to talk to right now, and I thought I went over it, but maybe I didn't. The person says, does information sharing still apply when a youth is over 18, enrolled in post-secondary education, but they're still in foster care? And the answer is yes. The Uninterrupted Scholars Act has some guidance that says that when children are over 18 and they're still the legal responsibility of the child welfare agency, we treat them as if they were under 18 for purposes of sharing information with caseworkers. And this is important for jurisdictions that have extended foster care. All right, so one question you might have is how state law interacts with FERPA, and we've already talked about it a little bit because I've mentioned exceptions that require state authorization. But the general rule is that FERPA provides the minimum requirements for guarding privacy of education record, but states can provide more privacy protections. So, for example, states can limit the number and type of juvenile justice officials to whom disclosure is permitted. And as we mentioned in the juvenile justice exception, you have FERPA exceptions that require state law authorization to be effective. Two final notes I'd like to make are on sharing education records for performance evaluation and policy development. This slide was particularly for researchers. Doesn't seem as though we have a lot of researchers on the call, but I'll just go over them quickly. This presentation has been more focused on sharing of education records for individual case planning and service to students on the ground level. But we also know that education records could help us understand and develop policies and to evaluate our performance when we put in place these policies. So 2 points I'd like to make towards that are, one, FERPA does have a research exception, and that specifically says that organizations conducting certain studies for or on behalf of the school can, for research purposes that are delineated in the statute, use de-identified information. And one particular purpose in the statute that might apply, that oftentimes applies, is to improve instruction and to improve instruction. But the important part to note when you have information that's being shared for research purposes is that confidentiality protections must still be ensured by anybody who's doing research on information that's been de-identified for research purposes. And a final note that I'd like to make is that the Uninterrupted Scholars Act, the statute itself, is silent on whether information can be used for research purposes after it's shared with a caseworker under the Uninterrupted Scholars Act. But an important point to note is that if information is de-identified, it would be potentially usable for research purposes if the other research exception requirements are also met. So now, where can I learn more about information sharing for juvenile justice involved youth? As I mentioned, Family Policy Compliance Office website is a really great place to start. Another source would be our publication on understanding FERPA, which will be available and will be emailed to you. Another great resource is the MacArthur Models for Change Information Sharing Toolkit, which is available on the website mentioned above. Additionally, there will be a training coming out of the Robert F. Kennedy Children's Action Corps. That'll be available in August, and any of you who are on the Education for JJ Youth listserv will definitely get an update about that. If any of you who are listening to this webinar would like to be included in that listserv, just let us know and we'll make sure that you are on that listserv. And finally, you have the Legal Center for Foster Care and Education that has released some publications. One that's highlighted above is How the Uninterrupted Scholars Act Helps Caseworkers Access Education Records. So I'm going to put my contact information up on the screen. My coworker, Jessica Fireman, who couldn't be here because of the snow, her contact information is up on the screen as well. I'm going to check the time. We have 13 minutes, so let me see if I can get through some of these questions. How about releasing to a child's GAL in an abuse-neglect case without a court order? So under the Uninterrupted Scholars Act, that could be potentially a redisclosure from if the information went from the school to the caseworker and then the caseworker needed to release it to the child's GAL for purposes of meeting the child's educational needs. Let's go back to the slide on redisclosure. So it would have to meet this. It would have to say to an individual or entity engaged in addressing the student's educational needs. And that oftentimes is what a GAL in an abuse and neglect case would be helping with. So I don't see how that would be a problem, and it would likely fit under the redisclosure part of the USA after the caseworker had received the information. Let's see. File updated. So I had, this question says, in child welfare, we have to file updated child education records as part of the judicial review, and copies go to the parties as part of the judicial review. Is that redisclosure allowed? I guess I'm confused as to who we is. Is we the caseworker? And if so, if copies would go to the parties, you're talking about the parents as part of the case file? Or are you talking about the court? I'm sorry, I can't see the answers to those questions, but maybe in a minute I can get clarification on this. And let me go on to the next question. So there's a question about if a student has a juvenile probation officer and the probation officer is claiming 4E reimbursement and the student is living at home, does the probation officer have access to the education records? I believe that the child can't be living at home to get 4E eligibility or to get 4E reimbursement, but I am not an expert on 4E reimbursement, and I would say that you should probably check your state's 4E reimbursement scheme. It would see this, the second bullet that says you look at your state's laws and regulations that define when the child welfare agency has legal responsibility. I would definitely do that in your situation. And let me see if I have any other questions. So we answered the question about when a child is over 18. And I think that's, the site for the guidance on whether a foster parent is considered a parent. Let me go back to that. And then I think we'll be done. And I can answer offline the other question that the person had about the case file and redisclosure. I can answer that offline. So, the site for whether a parent, oh, here you go. That would be 61 Fed Reg 59291 and 59294 in 1996. That's the FERPA defines who FERPA defines a parent as, and some federal regulations that can help clarify whether the federal regulations support a parent as being, including a foster parent. All right, so I'm going to wrap up the presentation now. If you have any questions that I didn't answer during the session, feel free to email me. Also, look out for an email soon. I'm going to put I'll try to skip to the last slide so you have my email. You feel free to email me, and also stay tuned for the PDF of the PowerPoint and the publication as well. Thanks again.